Good day, everyone. My name is Rowan Haarhoff. I'm the business manager of Munro Forensic Actuaries. Welcome to our series of pod shots. It's not a podcast, it's a pod shot. It's like a shot of espresso meant to go straight into your brain to help you figure out the actuarial stuff we're about to discuss. And today my guest is Willem Boshoff. He's one of our senior actuaries. In fact, he's the one who mostly appears in court for us, has a lot of experience around how the actuarial methodologies are addressed within loss of earnings and loss of support claims. So Willem, welcome. Thank you for joining me today.
Thank you, Rowan.
All right. So let's get on with it. Today's topic, we are dealing with contingencies. It is a topic that is often, in fact, all the time would be addressed in any loss of earnings or loss of support claims. And today we want to look at how that is applied, what are the risks that are involved when applying contingencies, what are the legal considerations that we should be looking into, and how you as a practitioner would be able to better understand how contingencies work and possibly how to instruct your actuary. Okay, so let's then get into that. Let's start talking about contingencies and the factors that we should be applying. So the first thing I think I really want to start with is, can you just briefly explain in as layperson's terms as possible what contingencies are?
So contingencies are there to make allowance for risks that aren't explicitly quantified. And we refer to these risks also as the vicissitudes of life or life events. And that generally has a negative connotation, but it doesn't only have to cover negative possibilities. It could also cover positive possibilities. And the way contingency is applied is a simple, in the case of loss of earnings, it's a simple percentage reduction from the value of earnings. And for loss of support, it's typically a percentage reduction that's taken from the claim amount for each individual. And it goes without saying that contingencies are a fairly blunt instrument. It's at best an approximation of the quantum of all the risks that should be covered by them that are dealt with in the simple percentage reduction.
Okay. And in our discussion today, are we going to be basically looking at this idea of how the contingencies are applied to the value of earnings?
Yes.
And what is the value of earnings? Is that the loss that you arrive at after the calculation?
Yeah, so I mean, for loss of earnings, to determine the loss, we will value the person's earnings pre-morbidly, so had this accident not occurred, and then all the incident, and then also post-morbidly, now that the event happened, what's the likely earnings. And the difference between those earnings, is the loss.
But so you're not applying the contingency to the loss, you're applying it to the values of the earnings, and that then results in the loss.
Yes, that's correct. So if you reduce the earnings or the pre-morbid earnings, it will reduce the loss, and if you reduce the post-morbid earnings, it will increase the loss.
So an attorney watching this, could they apply that principle that you've just elucidated now as a general principle to approaching contingency for post-morbid, for pre-morbid and post-morbid?
Absolutely. And, I think for us, it's pretty intuitive, but I've been at court in negotiations where guys actually confuse the impact of, what side of contingencies, whether it's post or pre-morbid, and what the impact is. And we've seen arguments where the intention is to lower the loss, and then you get instructed to actually increase the contingencies on the injured. And then we go, well, that has the opposite effect, or, whatever the case may be.
Okay, so that's a really important principle for attorneys to remember. In your early explanation, you spoke about uncertainties or vicissitudes of life. Can you just unpack that a little bit more and explain what that means?
Well, vicissitudes of life that we consider here are generally factors that impact on a person's earnings or their earnings capacity. And these factors or risks are really innumerable. There's too many of them to list, but some have a bigger impact than others.
And some examples?
Yeah, so I mean, obvious one is the risk of unemployment that should be considered. And then there's also, given that the value of the earnings path or a career is typically based on not only a person's earnings at a certain point in time, but also likely future earnings. So there's risks that the person's career path could be better or worse than that postulated. There's other risks in terms of their earnings, so a risk that tax could be higher or lower than what we've made allowance for. There's risks in terms of their retirement age, that they might have to retire early. There's risk regarding their health, their personal circumstances, any kind of trauma that might happen in life could really impact on a person's career. And all those factors are allowed for in this one broad number. If I think of loss of support as well, there's very specific risks there as well. So and not all are risks. I mean, I use the term risk loosely as to explain uncertainties. But there's life events like a divorce or adopting a child that could also impact on the claim amount.
And so all of those factors that you mentioned, and we spoke about this earlier, are really not within the area of the actuary, because they don't know the claimant, right? This is where we're relying on, I assume, the industrial psychologist or the attorney to be able to be making sure that they understand those future risks that might impact on the career of the claimant.
Yeah, that's correct. And we generally don't see even industrial psychologists going too deep into the individual factors. We can't, because it can become incredibly complex. And it's also, one could easily focus on a negative factor and then ignore a concomitant positive factor.
So Willem, given everything that you've said, is there any scientific basis for contingencies?
Not really. The approach to contingencies, which we will discuss, has been used for decades, and it seems like there's general acceptance that methodology has a strong correlation or resemblance with reality. But there isn't, to my knowledge, any actuarial or economical model that can accurately quantify an individual's contingencies. And that is due to the complexity that's involved. Like the factors, the risks are individual and they are innumerable, and to quantify all of that accurately is near impossible. Maybe something that will be done in future, but we're not there yet.
Yeah. Okay, so let's get into a little bit of detail. So how are contingencies determined?
So typically pre-morbid contingencies are determined first, and then your post-morbid contingency is decided on in relation to your pre-morbid contingency. The post-morbid contingency is typically higher because there is more risks at play for an injured person. And the difference between the two we often refer to as the spread. So if there's a pre-morbid contingency of 15% and post-morbid 25%, then the spread would be 10%. So we get standard contingencies, and these are 5% past and 15% future pre-morbidly, and 25% future post-morbidly. Post-morbidly, there's not normally a past contingency because the past is generally known and there's not much uncertainty around that. And this methodology is generally accepted by the RAF as well. But when cases get closer to the point of settlement or going to court, there's often more focus on what the best contingencies are to apply, or the correct ones. Dr. Robert Koch in the Quantum Yearbook cites a sliding scale that's often used in the courts, and that is 0.5% per year for the period under consideration, and that's now for pre-morbid contingencies. And this methodology has many judgments supporting it. To cite just two judgments is Hall versus Road Accident Fund, and then also Road Accident Fund versus GSO Guedes. Dr. Koch further suggests simplification to the 0.5% per year sliding scale, and that is, he suggests using 25% for children, 20% for youth, and 10% for middle age. I assume somewhere between youth and middle age we will use the 15%. But importantly, he does not give specific ages for what constitutes especially children and youth. But this approach has nonetheless been accepted by the courts. I've seen a few judgments that has accepted this methodology. And Dr. Koch also cites two of the seminal judgments regarding contingencies in justifying this simplified sliding scale. And the cases he refers to is Goodall versus President Insurance, and then for children, Southern Insurance Association versus Bailey.
So when we get to court, how practically are the pre-morbid contingencies decided upon? What actually goes down?
Yeah. So when we do our reports, most of the time we get a simple instruction to apply standard contingencies, 5 and 15%, or for children and youth, we'll often get the instruction to use future contingencies of 20 or 25%. But when things get closer to settlement or closer to court, in our experience, we've found a greater focus on the 0.5% sliding scale. And the question for children is should we allow for contingencies only in terms of the 0.5% per year sliding scale? Should we allow only for the period of their career, so from the date they start working or would have started working till the expected age of retirement, or should we also consider the period between our date of calculation up to the date that they would have started working? And it doesn't seem like there's a clear answer to that. If we consider the typical career, and I would say somewhere between ages 20 and 65 is where the most people, that would be a full career. The implication there, that's a 45-year career, and using the 0.5% per year rule, that implies a contingency of 22.5%. However, the courts, do allow for higher contingencies, and we've also seen judgments that specifically address this issue. For instance, I'm reading from the judgment of in B versus Road Accident Fund, and this is a Supreme Court of Appeal judgment. The court ruled, and the judge said, "I do not think with respect that one can speak about normal contingency deduction for loss of future earnings, at least not without taking into account the age of the claimant. For obvious reasons, the younger the victim, the longer the period over which the vicissitudes of life will operate, and the greater the uncertainty in assessing the claimant's likely career path." At the same time, we've recently seen a judgment in the Cape Town High Court of CDK on behalf of CLK versus RAF, where there was specific reference to the child's career. So in this instance, it's a child aged 8, so there's a considerable period of time until their career starts. And the industrial psychologists in this matter, both of the plaintiff and the defendant, agreed that their career would have spanned from age 22 to 65, and that is a 43-year period. And in this instance, the plaintiff requested a 25% contingency, which accords with children based on cost simplification. The Road Accident Fund requested 30%, and the court actually awarded 21.5%, stating very clearly that the 21.5% is arrived at 0.5% per annum for the 43 years of their career. So in this instance, the period between the date of calculation and the commencement of the career wasn't factored into the contingencies. Referring to, again, one of the foundational judgments in Southern Insurance Association versus Bailey, I think one has to note that a 25% contingency was applied there for a young child, which if we apply the 0.5% per year rule strictly, it would imply a 50-year career, which is unlikely. But rather that there's allowance for contingencies for the full career, and in addition, some contingencies for that period between the date of calculation and the commencement of the career. But obviously, that part is then addressed with a much lower contingency than 0.5% per annum, which I think is appropriate. But there is, however, a dynamic that I think it's very important that people understand it. Now, firstly, just in my opinion and also in my experience, is for employed individuals or individuals who are at the age where they could start employment and they are expected to work a normal career to say age 65, the 0.5% per annum is a good approach. I wouldn't tamper too much with that. But there's an interesting dynamic that comes into play if we consider a long period of time. And this dynamic is a result of the way the 0.5% per annum is calculated, and that is additive. We add 0.5% to the contingencies for each year that we want to apply the contingencies for. Now, this approach, this additive approach, we refer to it as a linear increase in the contingencies. Now, the difficulty with that is best explained in an example. We've run the numbers on our actuarial basis, and if there's an actual case, we consider it a an 18-year-old male claimant who would have started employment at age 18 and would have earned a certain amount in real terms for the entirety of his career, which is slightly unrealistic, but it serves to illustrate the principle. If we allow for this individual to work till age 65, the period of his career will imply a 23.5% contingency if we stick to the 0.5% per year rule. Now, for the same individual, if we go and we say, well, we extend your career from age 65 to 75,
Right.
logically, one would expect that the value of his future earnings will be higher. All other things equal, he's just working for 10 extra years. Surely the value of his earnings should be higher when he works till age 75. But because our contingencies increase from 23.5% to 28.5% with this additional 10 years, we actually see that the value of future earnings decreases. Now, that's completely counterintuitive, and it explains an important principle. This principle we refer to as the linear risk adjustment distortion, and that simply says that you actually overcompensate for risk if you linearly apply risk to a value or a capitalized value for each year that you add in the future, the further away you are in the future, the value of that year's earnings reduces exponentially. So there's a decoupling of the two dynamics. The one increases linearly and the other one actually decreases exponentially. Now, this exponential decrease in earnings, the further we are in the future, the exponential decrease to the value of the earnings further into the future, is because of mortality increasing and also because we discount with compound interest. The linear risk adjustment distortion is not always that apparent, because the example that I used, I assumed constant real earnings. In practice, often the earnings of an individual will increase the older they are, and that dynamic might always result in a longer career having higher capital value, even if we apply contingencies at a 0.5% sliding scale. But the underlying principle remains the same. And that's maybe best illustrated with an extreme example. So hypothetically, if one could have a 200-year career, one would expect the 200-year career, the value of those earnings to be much, much higher than a normal career. However, if we stick to the 0.5% rule, we would apply 100% contingency and actually say that somebody with a 200-year career's earnings has no value. And that illustrates this dynamic that's at play here.
So this, as you call it, this linear risk adjustment distortion, the way you've explained it, it's, to someone like me, sounds quite complicated. How would an attorney approach it or approach a claimant whose career is beyond 65? What sort of practical advice would you give them in that sort of situation?
Yeah, so first of all, and I have been asked in court to provide my opinion on this, I think generally the 0.5% per year approach is sound and it operates well within a certain time frame. But once we get to a time frame of over 50 years, so over a 25% contingency, I would say the linear risk adjustment distortion becomes too big, and one should probably not have contingencies or pre-morbid contingencies of higher than 25% for the future, unless there's a very good reason to have that, to use a higher contingency.
And can you imagine a good reason? I mean, just again, if it's even as hypothetically?
We have seen many instances where much higher than normal pre-morbid contingencies are applied, but then the court would typically cite very specific reasons for that. And off the top of my head, what we've seen is, for instance, if it's deemed that the uninjured or pre-morbid earnings postulation is too optimistic or not well supported, the court might decide to apply a considerably higher pre-morbid contingency. We've also seen it where the earnings survey is used to determine earnings for Patterson levels as limited application, and very specifically the corporate survey earnings that we often use, because these surveys are the most accurate ones. They have the best data, but they're actually applicable to a small subset of the population and also happens to be the highest earning subset of the population. And those earnings does not necessarily apply to the wider population with the same qualifications. And the courts often deem it necessary to reduce those by more than normal contingencies. And lastly, a case we also see is when an individual had a history of unemployment and the court specifically wants to make additional allowance for unemployment, that could also increase the contingencies.
And what about individual health and lifestyle factors? Why should or shouldn't those be considered?
Yeah, there are so many of them, and the risk is that one could hone in on a specific negative or positive while ignoring offsetting factors. I've been involved in a case where the claimant was a smoker and had a drinking problem. And the argument was in that instance that it shouldn't be addressed via higher contingencies, but actually via a different mortality table. But I think the principle holds. And our counter argument was simply, what is this individual's eating habits like? What is their sleeping habits like? Because if you want to consider things that could have a negative impact, surely you should also consider the positives and see how all of that interact, which becomes a very complicated exercise. And again, that's why I think generally we stay clear of it.
Right. So how then, we've been speaking about pre-morbid contingencies, how are post-morbid or the injured contingencies then applied?
So typically post-morbid contingencies are applied with reference to the pre-morbid contingencies, and a spread is determined. And that spread is, in standard contingencies, 10%, but in many cases it's higher because a considerably higher contingency could be validated.
So Willem, in what circumstances are higher than normal contingencies applied in the post-morbid scenario?
So the medical experts normally provide the reasons, and they will elaborate on that. I've seen many industrial psychologists refer to the sequelae of the accident or the incident in question and the impact of that on the claimant's employability or the earnings capacity. And there's many reasons. The pain from injuries, the physical defects, etc. It might not render them unable to continue with their career or employment, but certainly puts them in a much worse position. And that could be addressed by a high spread in contingencies.
So then, in terms of the actuary providing an opinion on post-morbid injured contingencies, do the courts ask actuaries to give their opinion?
Not in my experience. I haven't been asked to give an opinion on post-morbid contingencies. Actuary Greg Whittaker, the representation to SIOPSA, that's the Society of Industrial and Occupational Psychologists, in 2018. And Greg did some research around the phrases used by IPs, or industrial psychologists, in their reports, and then the contingencies awarded by the courts. And based on certain phraseology, he drew up a table to state, what the typical contingency would be that's awarded concomitant with the phrase. For instance, if the IP said slightly higher, it would typically mean a 5% spread. And there's a number of phrases he cites. Higher would imply 20%, considerably higher would imply 45%, and there were a few others. Time will tell if this becomes an accepted approach. In my opinion, there's still a huge amount of subjectivity. It certainly is a very good attempt to provide some guidance and guidelines around this. But it's still very dependent on the vernacular, on the phraseology used by the industrial psychologists and what they actually mean.
So when we consider the role of the industrial psychologist in helping, whether it be the attorney or the court, determine contingencies, there seems to be, at least from what you said now, almost a need for industrial psychologists to become more accurate around the phrases that they use so that there can be more certainty around their opinion as to the future risks. Would that be a fair comment?
Yes, I certainly think it would be helpful if there's some guidelines for industrial psychologists around the phrases they use or the descriptive terms they use and what that would imply for contingencies.
Okay, so Willem, as we get to the end of our conversation, one of the important questions is, so who should calculate the contingency? Should it always be an actuary?
No. Often the application of a contingency is just a simple percentage reduction to the capitalized value of earnings, which the actuary will calculate, and anybody with a calculator can apply it. However, specific to the road accident fund, if the road accident fund cap applies, the contingencies have to be applied before the cap is the impact of the cap is calculated. And in those instances, only the actuary should apply.
And why is that? What differentiates a non-capped loss and a capped loss with respect to who calculates the contingencies?
Yeah. So for a capped loss, for each year under consideration, you will capitalize the earnings and then both pre and post morbidly. So you will have a capitalized loss for each year, and each year's loss is then compared to the cap. And if the loss is higher than the cap, the maximum loss allowed for that year is the capped amount. If we allow for contingencies, the contingencies reduces the capitalized value of earnings for each year and consequently the value of the loss. That must be done before the application of the cap. So after the application of the cap, we'll have a capital value of the total loss. If we apply contingencies after the cap, so in a way that somebody with a pocket calculator can do it, what you would have is you will have an already reduced loss that you now further reduce with contingencies. And there's a number of judgments that make it clear that, the cap is the final instance. So contingencies should be applied before the cap.
All right, so based on your explanation, it's very clear that if the road accident fund cap applies, then the actuary has to calculate the contingencies.
Yes, that's correct.
So as we come to the end of our conversation, Willem, I want to thank you for your time today and for the preparation that you put into making this all happen. So I just want to pick up on the calculation of contingencies. Munro has a unique product in the market. It is via our online Connect portal, which is available to all our clients, and it is a contingency calculator. This allows you as our clients to go and calculate contingencies for any report that you have done with us, and it allows you to calculate it not only in uncapped matters, but in capped matters as well. And what an added benefit to this is that you can do this on your mobile phone, which means that you can even do this at court while you are standing down a matter or you're involved in settlement negotiations, and then you will receive an addendum report with all our actuary signatures, which has been accepted by the courts. And finally, if you have any comments, will you please leave them in the section below or email us at actuary@munrofa.com. We also have a rich reservoir of resources that you can access via our website. Two important ones would be the Connect portal, if you're wanting access to our Connect portal, as well as Munro TV, which points you to our channel on YouTube, where you can find the podshot that we're doing today and many other podshots, as well as videos that we have done in the past. Thank you for joining us, and I look forward to seeing you at our next podshot.